Assalamu alaikum, good evening viewers. Welcome to another edition of Legal Ease, where we try to make the law as easy for you. We convert legal jargon into everyday English. And as usual, this program, we're covering labor relations, we're covering labor law, we're talking about dismissals. We've got a guest here who's been on the show before, so I almost look at him as a co-host rather than a guest. We're going to be talking about retrenchments because that's where we left off the last time with Advocate Ronnie Bracks. Ronnie, thank you really very much for making yourself available. You becoming a regular feature on this, which we really appreciate. But when we were busy the last time, there were a lot of questions coming in, and some people said we didn't get a chance to ask our questions, and therefore we're back here.
Right.
But viewers, we're going to talk about retrenchments because the number of retrenchments have increased recently. The CCMA are dealing with additional numbers of retrenchments. The bargaining councils are dealing with retrenchments. So we're going to be talking retrenchment. But we also can talk about other forms of dismissal. So after the first break, we will invite you to call in. If you have any questions, please feel free to call in and ask Ronnie any question on dismissals and perhaps any question on labor law, and I'm sure he'd be happy to answer. Ronnie, thank you very much for making yourself available.
It's really indeed a pleasure. I mean, I enjoy coming onto the show. I must say there were a lot of people who were clamoring, asking all kind of things, how to get hold of me and all this kind of information, which is actually quite exciting because it means that there are many people there who need the advice, and often to get this advice doesn't come cheap because attorneys do ask an arm and a leg and maybe even more than that sometimes. So we help where we can. Yes.
Ronnie, to kick off, just in case there are viewers who haven't been on the program before, haven't watched the program before, they know what dismissal is, but often the word retrenchment is not used in context. So for a start, could you tell us not only what retrenchments are, but what the different types of dismissals are, just to get it going?
Okay. Now, and in terms of the LRA, you have what we call an unfair dismissal, which is a dismissal where you've gone through the process of a disciplinary hearing and you've been found guilty and the company has told you to go away. Then we have what we call ULPs, or and not to want to use the technical term, unfair labor practices. These are very specific and they are situations where the company had done something which goes against the grain of the workplace and you are dissatisfied with it. And normally here we deal with, for example, where there's an issue relating to bonuses, where an issue relates to in a situation where you've been disciplined but not dismissed, but you have been given a warning, would be one of those areas. And when it comes to training and those kind of other areas, you are entitled to bring those to the CCMA. And then we've got well, as far as when we talk of misconduct, under the same vein of unfair dismissal, we have incapacity. And incapacity is divided into two sections. It's medical incapacity, where for medical reasons, for example, you can't continue to be at work on a more regular basis, or you can't continue to work because the company can't utilize you anymore in the position that you have been. Although in as far as in medical incapacity is concerned, that often you could be utilized in a lower position instead of the position that you normally used to work in. So if you've been a forklift driver, you can't drive anymore because your foot was crushed in an accident, but now they can use you in the office. So that is the area where they're going to use you. And then we get to the one which is always the most problematic of them all, and those are the retrenchments. Correct. Retrenchments are referred to as dismissals that is not of anybody's fault. We call them no-fault dismissals. What does that mean? It means that neither the respondent, or the company or employer, or the employee is blamed for for the end of the service between them, the dismissal. And it's normally based on economic reasons. For example, if the company is not doing as well as they used to do, they're not exporting as many items as they used to, and they can't afford to have the employees in the employ anymore, they would then embark on what we call a retrenchment. The other reason for that could be that the company has restructured, and in the process of the restructuring, maybe they have now replaced their manual workers with robots that they have imported and they've spent a lot of money on. Those workers are no longer utilized in the organization, and they will embark on the retrenchment process. And then the other thing that can happen, for example, is that your position in the company may have become redundant. Right. The CEO or the CEO that used to work there has now been dismissed, and they believe that they don't need to appoint a new CEO or a COO, and somebody else can do the work. But that means there's an extra body, the PA to the CEO or the COO is there, and her position then needs to be dealt with, because what do they do with her now? Because there's no person that she's no longer reporting to. And so under those circumstances, it would mean then that they have to then ask that person to leave the organization. So that is what we talk about when we deal with retrenchments. Now, the law has found it necessary to, in Section 189, set out exactly the process that needs to be followed. And the core of the retrenchment process is the consensus-seeking consultation that needs to happen. And that consultation forms the basis of any retrenchment. In fact, that is where the whole thing hinges on. And what does that mean? It means that the company needs to engage seriously with the employees, and if the employees are represented by a union, they will engage with the union. Or if the employees are not represented, they will engage with them individually in order to save jobs. Because that's what the whole purpose is, that the law does not want to see people without work. I mean, their work need to be protected. And the way in which that is done is, of course, by seeing whether or not there are other positions that we can place these people in. Part of that exercise is for the employees to engage in a process where they can suggest to the company that, look, I think maybe you can use me in this position. Or alternatively, maybe we can do this or that. Maybe we can, to be foolish, drop the extra biscuits that we normally get with our tea, so that we can save money, so that we can... And that is what the consensus-seeking consultation really is all about. But more seriously as to how can we prevent people from having to leave the company as a result of the retrenchment. And that process means that there needs to be serious engagement between the employer and the employees. And that is often where the problem really comes in, because companies do not have the time to be able to sit around and do these kind of things. So they normally look for the shortcut. And often when they do appear before us as commissioners, you find that there is always a flaw in that process, because that process hinges on what we call the substantive issues for dismissal. Because if the procedure is not properly followed, it can then lead to the substance for the dismissal not being followed properly either. And so what needs to happen and it's very, very important, because companies tend to miss this point. The law is very specific. When the company becomes aware that there might be a need to retrench, at that point in time they need to inform the people. Not inform them a month down the line and say to them, by the end of the month you've got to go, because we can't afford you anymore. So because they would have known, and if it's, for example, an economic reason why they are retrenching, they would have known from their balance sheets some time back already, because these things are produced quarterly. Yeah. I mean, the balance sheets might be produced annually, but the income statements are produced on almost, in some places, a monthly basis, other places a quarterly basis, depending on the kind of turnover that they're dealing with. And so at that point in time, you would know already whether or not the company is doing as well as it should. And so that is where the biggest problem comes in, is that when they become aware of it, they don't tell the employees about it. And so closer to the time, suddenly the employees are surprised. Because you see, if they inform them long before the time, then at least the employees can begin to prepare themselves that there will be an issue that is happening. But in most of the cases where people are complaining and where people have been asking questions about how this needs to be dealt with, is a situation where they were informed 2 or 3 days that by the end of the month we're going to retrench you, etc., etc., etc.
Ronnie, it's time for an ad break, so hold that. Viewers, it's time for an ad break. Please stay with us. After the break, we'll continue with retrenchments. Also, we'll have the phone number on the screen. You will please call us if you have any questions, if you have any comments about retrenchment or any form of dismissal, or you've got a case at the CCMA or you've got a case at the Bargaining Council. Please feel free to call in, and Ronnie would be happy to answer your question. Viewers, welcome back. If you've just joined us, we're busy with Legal Ease. We've got Advocate Ronnie Bracks. We're talking about retrenchments, but you can call in if you want to about any form of dismissal. Just before the break, Ronnie was telling us that in order to retrench, there are 2 requirements. One, there must be a valid reason that the employer needs to retrench, and the valid reason is based on either economic reasons, because the employer cannot afford so many employees anymore, or they're restructuring, in other words, they're working smarter, or for technological reasons, because they're changing technology, so therefore it is necessary to retrench. But what Ronnie also said, before the employer can dismiss, because the retrenchment is a dismissal, the employer must consult with the employees that are affected, and of course if there's a union, obviously with the union, must consult on, very important, is ways and means of avoiding retrenchment. That is key. There are other things to consult on as well. Ronnie, let's go back to that. But viewers, the number on the screen, in case you have any questions about retrenchment, or you've got a case at the CCMA, or even if it's a misconduct or incapacity dismissal, the number is 011-086-7777. Please feel free to call in. Now, Ronnie, we were talking about, yes, and you said they must follow a procedure, there must be a valid reason.
Yes. And before the notice is given to retrench, and that is what triggers the retrenchment. The company must be sure that they meet the requirements for those reasons. And under normal circumstances, what would be included in the notice, they would say what is the reason for the retrenchment, whether it's financial reason or economic, technical reason, or is it a structural reason. And they would then give the employees an opportunity to be represented if they are not represented. Alternatively, if there's a union, they will rope the union in, so that in order for the whole discussions in respect of the retrenchment process needs to determine. Now, as I said to you earlier, is that because the aim of the discussions is to try and save as many jobs as possible, they would embark on what we call alternative positions, trying to find alternative positions within the organization to be able to see whether or not they cannot place some of the employees into those positions. And sometimes what companies often do right at the beginning is that they embark on a process which is called voluntary retrenchment.
Okay. So people can volunteer.
So people can volunteer. So you most probably 55 years old, and you really seriously want to go on retirement. You can take early retirement, which means that might open up a number of positions for people to be able to fill in. Other people might be tired of working for the company. And they might decide that maybe it is time for me to leave. It's important to note that you can't ask for voluntary retrenchment. It's not something that you can make an application, but it doesn't necessarily mean that you qualify for the position.
Because there must be a valid reason.
Yes, because a lot of people who, for example, are some of the senior employees of the organization, see this as an opportunity to make a new start a new business, or do something with that money retrenchment package that they can have. But the company also, on the other end, needs to protect their operations. So if you've got too many senior people exiting, you're going to end up with a problem.
Or highly skilled people.
So the company, even though they might put out voluntary retrenchment there, they still have the right to be able to determine whether or not they're going to enter into an agreement with you with regard to voluntary retrenchment. And I had, for example, somebody who came to me and said, but I said to them, I want to be voluntarily retrenched. They said no, and now I want them to retrench me. I said, but you can't force that on the company. That is why it's called voluntary. An agreement needs to be reached between the parties. Other people who in one occasion, people who were not targeted in the company, they targeted only one division. That division, they had identified the people in it, and they were going to retrench. And somebody from, and let's say we're dealing, for example, with the sales division. They targeted them because they wanted to reduce the numbers there. The manufacturing section then, members came from the manufacturing section and said, we want to be included in that retrenchment. It doesn't work like that.
Because it's usually the people who know they can get jobs easily.
But that is the
ones that will volunteer.
Exactly the point. That is exactly the point. And people who, and as I said, who believe that they can do better, maybe on their own, because sometimes you're in an industry where you can see that there are ways in which I can make money from this industry if I go on my own, because there are, and one needs to guard against that danger, because sometimes you are sitting with a contract that doesn't allow you to be able to operate with the clients of the company that you're presently with. So you might think that you will make a lot of money going on your own, but you'll find yourself that you are restricted with regard to the people, and we call that restraint in trade contracts. So you can't interact with the clients of the company because you believe now that you can do better. So when they've done that exercise, and that exercise actually is an important exercise in law, because if you fail to identify alternatives, it can be seen that you have not followed the correct procedure. And our courts have been very specific about that, is that companies have to go through the process of identifying whether or not there are alternatives. And as I said right at the beginning, there's a specific reason for that, because you don't want people to lose jobs when they could have still been working within the company. The other area that's normally targeted is, for example, if the company is outsourcing some of their work, the contract workers, they are normally, under normal circumstances, the first to go.
Correct.
Because that means that those opportunities that is being now given to the contract workers can now be given to internal staff to be able to do those kind of things that need to happen.
That's one of the things they consult on, is how do you select people to be retrenched?
Yes, now you raise a very, very important point, because part of the as you say, of the selection criteria is dependent on what is agreed between the company.
Correct.
And often LIFO is the one that is often used, which means that those who came last will be first out.
Okay. And LIFO is last in, first out, just for the viewers who may not know.
And then FIFO is the other way around. Those who were first in will be first out. And normally that is when we are dealing with people who have are almost there at retirement age.
Right.
And you want to keep the blood alive. And one needs to guard against it, because it could also be seen as some kind of a discrimination. So there needs to be an agreement between the parties as to how they do it. And other ways of doing it, for example, we will retain the skills that needs to be retained within the
So when
organization.
you do LIFO, that's an important thing.
That's an important thing to remember. And once there's an agreement with regard to all of those kind of things, then of course we can then start with the process. Now, if you're unhappy at the end, if you believe that, look, despite the fact, and often it happens that agreements are reached, the company ignores the agreements, and then under those circumstances the company proceeds, and the retrenchment is found to be unfair. You then have the right to be able to refer your matter to the CCMA. Now this is where we need to just clarify some of the things that needs to happen. And when every matter that involves labor makes its first port of call at the CCMA.
Okay.
So of all the dismissals that I've spoken about, your first starting point will be at the CCMA, or I must also add, because we need also most probably dealing with people who are with bargaining councils, or with the bargaining council. Now, not all matters are normally the bargaining council will have jurisdiction to deal with. So you need to most probably in the end identify which are those matters that the bargaining council will be able to. But for the purpose of retrenchment, we will start with it and say that is where the first port of call was going to be. Now, when parties appear in front of us, there are different ways in which we deal with this kind of thing. The first is we determine the number of people that have been retrenched. If one person has been retrenched, irrespective of how many people have been consulted, because we must remember that for each and every retrenchment, you can't just have one person, unless of course that was the only person, and the CEO example that I used, that is the only person that worked for that person, right. And they get retrenched and they didn't do any other work in the organization, then you can have only that one person that you consult.
And you can't place that person
and you can't place them elsewhere. Then that is the only person that's involved. But in most cases, even if we end up with only one person being retrenched, there is a number of other people that may be affected by it.
Right.
And so your discussions during retrenchment will go across the board, either that department or the company, if it's the company as a whole that is being targeted for retrenchment. And it might end up, because other people are now being placed in jobs, that you are finally the only person that's being retrenched.
Right.
And because they can't find any other way to do it. So that person can come to the CCMA and refer their matter to conciliation, which is the 7-level referral. And then if the matter is not resolved, to arbitration, which is the 713.
Right.
Special provision has been made for single people who have been retrenched.
Okay, so after the break we can continue with dispute resolution. In other words, people get dismissed. They believe it's unfair.
Yeah.
If there's a bargaining council with jurisdiction, you say they go to the bargaining council. If there isn't a bargaining council, they refer the matter to the CCMA. We'll continue with that after the break. Viewers, time for a break. Please stay with us. Ronnie will be here to answer your questions. So if you have any questions, feel free to call in. Even if you have a comment to make, if you have a case at the CCMA or at the bargaining council, if you've been retrenched, you're not sure whether it's fair or unfair, or if you're an employer and you need to retrench people and you're not quite sure what to do, please call in and Ronnie will tell you how to go about and what the procedure is. Viewers, welcome back. We're talking about retrenchments, we're talking about dismissals. Ronnie Brax was just telling us before the break that in order for the retrenchment to be fair, there needs to be consultation. Also, there needs to be a procedure in terms of how people are selected to be retrenched. And very important, employers must avoid retrenchment. And some of the ways they can avoid retrenchment is to place people elsewhere in the company. If that cannot be done, then of course, they can retrench. When we were about to talk about dispute resolution, he said that if only one person is retrenched, the procedure to follow is conciliation first, either at the Bargaining Council or the CCMA. If there's no success at conciliation, the next process is arbitration. And of course, Ronnie, if it's more than one person, and if it's more than a company with more than 10 employees, I suppose, then it's a different process.
Yes.
Could you tell us about that process?
Now, very interestingly, in 2015, for the first time, we had a new section introduced that deals with your smaller employees and companies, and it's really to encourage entrepreneurship, where companies employ less than 10 people. On previous occasions, we only had two sections. The one dealt with the single retrenchee, and then everybody else, which means for two and more, you have to go to the labor court to be able to have your matter adjudicated on. Now, with the introduction of the smaller businesses, the law had made provision for where a person has been operating for a period of 2 years, and they have less than 10 people that they're employing. Irrespective of the number of people that they are retrenching, they are entitled to come to the CCMA. Under those circumstances, provision is made for your small shops within the townships, for example, and we see that many of them are springing up, your superettes, your corner shop, your chisanyamas, where there are not many, your taverns where there are not many people that's employed under. Those are the people that provision is made for. Your cafes, etc. Now, the third category that we deal with is the category that involves more than 50 employees. So under those circumstances, the situation is very, very different. If two people are retrenched from any of those places that employ more than 50 employees, then under those circumstances, they are entitled to be able to bring their matter as a conciliation to the CCMA. And at the end of the matter, if it's not resolved, the CCMA would then issue a certificate which says that the matter needs to go to the Labour Court.
Right.
And then, of course, at the Labour Court, they will then make a decision accordingly. One of the other things that one needs to say about your bigger organizations, your holding companies, your big stores, chain stores where they employ many people, is that there's provision made for when there is a situation where there might be retrenchment required, that the parties can agree for a facilitation by the CCMA.
Okay.
So the CCMA will then appoint somebody that will come to the company to try and facilitate the situation between the parties. Now the role of the facilitator is very, very important, because he is there to facilitate the situation between the companies. He doesn't get involved in the process as one would think that he is part of the process, because he facilitates and advises the parties with regard to the kind of things that need to happen. And you have the scenario there that there needs to be a period of 60 days that needs to pass before the company can actually give a notice of terminating the employees' services. Where there's no facilitation granted, then of course there's a 30-day period that needs that the law requires needs to elapse, and then the parties can then refer them to the CCMA, where the CCMA will be able to facilitate that and try and see if they can't conciliate it and get the parties to come to some kind of agreement.
Ronnie, I think this is something important, because there are a lot of employers out there who are not quite sure how to manage a retrenchment.
Yes.
Are you saying, therefore, that any employer who's considering retrenchment can apply to the CCMA and say, please appoint a commissioner to facilitate the process for us. The commissioner then would obviously guide the process, but not get involved in the actual selection or how many people, but will tell the employer and the employees or the union what they may and may not do.
Yes, that's exactly the situation. Right. And of course, what it does is that it allows you to have expertise to guide you with regard to what needs to happen. Because a lot of the referrals result because the employer doesn't have any knowledge as to how it needs to unfold. Right. And their advisors sometimes are not experts in those kind of things. Because whether we like it or not, these areas that we're dealing with are areas that require expertise. And the CCMA's commissioners are trained to be able to come in and facilitate those kind of situations. And often they have had successes in trying to facilitate these kind of situations, because they would be able then to make sure that the parties follow the process right through to the letter of the law. Now, I have seen situations where, even though the companies have appointed facilitators, that they still try and do this thing a shortcut way by trying to do it quick.
Right.
It doesn't work like that, because once a facilitator has been appointed, there is a 60-day period that needs to elapse before you can begin to do anything further. And the aim of the facilitator, and facilitator is not there to run with this thing forever. He's got 4 meetings within which he needs to get the parties to come to some kind of an agreement with regard to how the matter is going to proceed. Because everything else that we have spoken about, that's exactly the process that's going to be followed once it turns out that there is no ways in which the company is going to be saved. I also know that often the CCMA has got programs in which they can actually assist the companies when it comes to retrenchment, so that they can then undertake and train while they people are going through the process of retrenchment, that they can skill those employees. Because remember, the employees will be without work.
Right.
So they need to find a job elsewhere, in any case, to be able to do that. And this is an opportunity where they are given skills that they can actually utilize in other firms, and it makes their chances of obtaining employment much better at the end of the day, because they will be able then to go away with a skill that they have learned from their process.
And sometimes the skill that they learn, they can sort of, if they're entrepreneurial, they can set up their own little business and in fact subcontract to the company that they were retrenched.
Yes, and that is what has happened in a number of companies, is that the company has now seen an opportunity to be able to utilize those people, whether it be on a full-time basis or on a part-time basis, because often what the company requires is breathing space. So that they can just, if they can, bring the company back to where it was. And remember, the other thing that often happens is that when the agreement is reached, part of that agreement could be that some of the people could be re-employed by the company in the event that those positions become available. Because it can happen that people most probably, if they have not gone through the issue of people retiring, that they've taken up that option that has been placed before them, that when people retire, those people who have worked for the company can be brought into the company. And the company benefits from that, because they don't have to skill those people into the workings of the company, because those people have been in the company and they have that kind of opportunity to be able just to take up where they have left. And so the company has actually a benefit that they have at the end of the day. The employee has got a benefit because he's now able to come back into a position and to be able to earn a living instead of having to now look around for other jobs. So provision is often made with regard to that kind of agreement. Now, what is important of that agreement, Mohammed, is the following, is that when the company fails to adhere to that agreement, the employees are entitled to come to the CCMA to claim that they had been dismissed. Because that is one of the requirements in terms of the definition, in terms of the Labour Relations Act, that qualifies that a person has been dismissed where there has been this kind of agreement and the company had failed to adhere to that kind of agreement. So companies need to be very careful. They can't just willy-nilly enter into these agreements with the hope of we want to get this thing over and done with.
Yeah.
And that seems to be the trend that most companies have, is that it's a process that we need to get out of, and if we can do this chop, you know, we can get on with our lives.
Or get rid of people that they're unhappy with.
And it's more serious. Now, this is where the other problem things, what companies also do is that we don't like Ronnie, because Ronnie is the big mouth in the company and he always creates problems. So when we are retrenching, he is one of the people who we will be targeting. Or alternatively, Ronnie is a poor work performer. And we are sick and tired of talking to him. We are sick and tired of counseling him. But we will use the retrenchment mechanism to be able to get rid of him. It's a big mistake.
Yeah.
If a person is not performing, or there is some other misconduct that he is doing within your organization, deal with that.
Yeah. Go the misconduct
and go the misconduct or incapacity route, because you're not going to be able to get away with the kind of situation where if it's retrenchment time, we will use him as one of the people that we're going to include, because you are going to find yourself in all kind of trouble at the end of the day.
Okay, with that, Ronnie, let's take our last ad break, viewers. We're taking our last ad break. After the ad break, again, the number will be on the screen. If you need to call in, please feel free to call in. Viewers, welcome back. We're talking about retrenchments. We're talking about dismissal in the workplace. We're talking about what a fair retrenchment is, what the procedures are. We're talking about facilitated retrenchment, facilitated by a CCMA commissioner. And just a reminder, the number is on the screen, 011-086-7777. Ronnie Brack's easier to answer your questions about retrenchment, about dismissals. Up to now, we've spoken about what is required in terms of procedure, what is a fair retrenchment. For example, it can be based on economic reasons, can be based on technological reasons, or for structural reasons. Ronnie also told us about selection procedure, where you can allow people to volunteer to retrench, but then the employer decides whether the employer accepts the voluntary when somebody volunteers, whether the employer accepts that voluntary application. The employer needs to obviously protect skills. Then, of course, there's the last in, first out, which is one of the possible criteria to use. There's sort of first in, first out, or first in, last out. These are some of the different approaches. But the most important thing in following the procedure is to avoid retrenchment. Ronnie also then told us about dispute procedure, where the first process is conciliation. Thereafter, depending on the number of people retrenched, depending on the number of people that the employer employs, if it's a small or micro business, less than 10 people, the process then is conciliation and arbitration. If it's more than that, Ronnie, it is conciliation and the labor court.
Yes.
Right?
Yeah.
But
now,
you've also said employer and employee enters into agreement that people who are retrenched, there's a phone call. Can we take the call before we deal with that? Assalamu alaikum. Good evening. Go ahead with your call. Hello. Good evening. Your question?
Hello, how are you?
good, thanks.
Well, thank you. Your question, please.
I'm one of the guys who was at work. So I just want to win the case of CCMA, and we agree with the employer, with the terms. What should I do next step?
Okay, you don't agree with who? With the employer.
I thought you said they agree with the employer.
Did you hear the question?
No, I didn't.
Viewer, could you just give us that question again? Hello? It looks like we lost
him,
the...
yes.
Okay. I'm not quite sure what the question was. It says we disagree, and I'm not sure I disagree
Well,
with you.
I heard him saying that with the employer, he said something about one of
Okay,
the
look
people
at
was-
different possible scenarios.
Yes.
Have we got a call on the line? Okay, there's different scenarios. Let's see
Yeah.
what possible question. Firstly, disagree with the employer, therefore
Yes.
can go to the CCMA.
Yes.
Disagree with the arbitration ruling of the CCMA. That's a
Yes.
possibility.
Well,
for the
if
cross-
they disagree with the arbitration ruling, of course, they have to review it with the Labour Court.
Okay.
So he has to take his matter then to the Labour Court for the Labour Court to make a determination whether or not the Commissioner had done anything that can justify the court interfering with the outcome of the Commissioner. Yes, and I mean, if they disagree, it depends on whether there's a facilitator that's been appointed or not, because normally under those circumstances they should have sorted it out with the facilitator,
Right.
and the facilitator would have intervened to try and see if he can't get an agreement between the parties with regard to the process. that
Ronnie,
is
you're raising
followed.
something really important. In other words, the safe option for employers
Yes.
is to go the facilitated
yes.
route.
Oh, yes.
Skilled person at the CCMA. The chances are the employees won't then have a dispute at the end of the process.
Yes, and you see, what helps, Mohammed, is that you have a third party who's not part of the operations, who sees issues from a different perspective. You know, when you're involved in all these processes, all that you see is that, and in fact, from the employee side, they're seeing, I'm losing my job.
Yeah.
From the employer side, he's saying that I can't afford to have these people around anymore. So we better make sure that we get into a process where our money, we don't run out of money in a short space of time.
Right.
So those are the interests. But the person from the outside is their interest is in resolving the issues between the parties, so that we have a win-win situation.
Right. They're not subjective, it's objective.
And that's it. And that's the beauty part of having a third party in this process, because he's got no direct interest in it. And all that he's interested in is we make sure that we save the jobs of those people if they can be saved. And that person will then listen to both sides and try and get them to a point where they are of the same mind. And that's the important part of it, because a lot of emotions are normally at play in this, because when people start hearing about being retrenched, and I mean, I've discussed this with many consultants, with many people, the first thing is that they say, what's going to happen to me and my family?
Yeah.
You see, and I've got children at school, I've got a bond to maintain, I've got a house, I've got a card that I need to pay off, all those kind of things. And often we act emotionally in the process. So even if there's a simple and easy solution, we don't seem to see that solution, because for us that is not the kind of route that we need to go. And often the facilitator is the one that says, well, have you thought about this? Have you thought about if you change, for example, into a shift system that you might be able to save people's jobs? Or have you thought about, well, maybe we need to cut down on the number of days that we have employees, and see whether or not that can be helped. And sometimes all of those kind of things is not something that's the uppermost in the mind of an employer, because in his mind is that I want this stuff out. You know?
Okay, Rodney, let me stop you there. There's a call on the line. Hello, good evening, Assalamu alaikum.
Can
Go
Hello?
ahead. Hello,
Hello.
go ahead with your question.
Hello, Ronnie. Ronnie, could you please explain to me, so let me go away from the TV. Can you explain to me, when you are 15 years at the company,
Yes.
and the company terminate you for not experience for your job? We are 3 guys for reps at the company, but they said they terminate me for not have experience for my job, because I'm a rep. We are 3 reps, 2 white and 1 black. They against me, but they said not returning. It's terminated because I don't have experience,
Yes.
but I have 15 years with the company.
Yes.
And can you please give me your number? your business number also. Thank you, Ronnie. Bye.
Okay, now that's an interesting question.
Yeah, very. I'm glad the caller called in because we often get this type of thing.
We automatically assume that if I've been in the company for a long time, that I have the necessary experience to be able to do whatever needs to be done.
Yeah.
But let's say, for example, that we're dealing here with and I think that we're dealing here with a situation of incapacity, where they are saying that the person has been performing poorly. Now, if that is the case, dependent on whether you're a senior in the organization or whether you're a junior organization, the company's approach is going to be different. Now, and I want to use me as an example. If I join an organization and hold myself out to be a senior legal advisor, and I'm not performing my job, the company will not go through the same process to address my shortcomings,
Right,
as it would do with a junior person. Now, under normal circumstances, if the person hasn't got the experience or is not performing as they should, they would normally take him through what we call counseling. They will set certain targets of the person to be able to achieve. They will monitor those targets on a regular basis and ensure that the person meets those targets. And if he still doesn't, then of course they're going to dismiss the person. Now,
okay, but Ronnie, just remember, this person says, I've been there for 16 years.
yes, now this
and
is where,
now suddenly
this
they
is now
say,
I'm coming to. Now,
okay.
now this can actually work to the negative of the person, because if he is now performing poorly, surely there must be a reason why suddenly after 15 years of work, because and he's correct, and they kept him there for 15 years, which means that in 15 years he would have gained the necessary experience. In fact, he knows the company most probably inside out. I mean, he's the kind of person that if the place burns down, he'll tell you exactly where the fire extinguisher is, because he's been there for such a long time. But it could also be as a negative. So there's two scenarios that seems to be unfolding here. The one is that the company wants to get rid of the person, so they are going through the process of using that as an excuse. Or alternatively, that the person has, most probably for the last couple of months or couple of years, not been performing properly.
Ronnie, can I stop you? We've got another caller on the line. We've got, I think, two callers. Hello, good evening. Assalamu alaikum.
Hello.
Go ahead with your question.
Yes. I asked, and the employer missed. So I took the same. So
excuse me, are you calling from a cell phone? Can you move around a bit? It's
Yes.
breaking up.
Maybe you're too close to the TV.
Try again.
Yes. Can you hear me now?
Yes,
Yes, that's better.
Yes. I just want to ask if I win the case, then the employer says to I win the case, and the employer said to me, they're gonna pay me only for maybe for 4 months, and I've been running around the case for 12 months. What should I do then?
Okay.
All right. Okay. Now, if you've won your case, if the company has not been, in fact, your award would have said by which date they were supposed to have paid you, if it's compensation that you received, or alternatively by which date you should have been back in your workplace. Any one of those two scenarios, you need to go back to the CCMA, so that the CCMA needs to put a process in place in order for you to get what is due to you at the end of the day. And the sheriff will then go out there and then attach whatever property needs to be attached. However, if you have been asked to return to work, to be reinstated, then of course you've got to go to the labor court to be able to institute contempt proceedings against the company, because they have failed to adhere to that.
But clearly, arbitration award has been granted.
Yeah.
The arbitration is either reinstatement or compensation. And if it says compensation for 12 months,
you go to
they go to CCMA, make it a court order.
Yeah.
And of course, the employer must comply. If the employer doesn't comply, go to the sheriff. Sheriff will then enforce that by either attaching property or some other way.
Yeah.
Okay.
The reinstatement, you then if it's still not complied with, you go to the Labour Court, then you start, they will then start the contempt.
Okay, Ronnie, half a minute to
Yes.
tell us about the previous caller in terms of the experience, 16 years experience.
Yes, I think that he's got the right to be able to take his matter to the CCMA and refer an unfair dismissal to the CCMA.
Because clearly, how can they after 16 years say you
no
don't
ways.
have experience?
No ways.
Unless
Doesn't
they're
make sense.
placing the person in a different position,
yeah.
but then he has the choice as to whether he
Yeah.
wants to accept the
Yeah.
other position or not.
And if they did place him in another position, then they should have then started the trainee process, because he might not be qualified to be able to work in that particular. Because I could be many years in the company as a driver, and then suddenly you now want me to be a security person.
Right.
And my experience might be very different, because I might not know how to do security work.
Or it may
under
be a
those-
promotion.
Yes, and you will then have to take me to the process of training me.
Okay, but we also know that sometimes employers, somebody applies for a job, a promotion period, and the employee needs to be careful about it.
Yeah.
Because the employee applies for that position,
Yeah.
gets placed in that position, and if the employee says, you know, yes, I can do that position, and cannot perform,
Yeah.
in spite of being qualified,
Yes.
then there's a danger that that employee can be dismissed for
yes.
incapacity.
Oh yes, oh yes.
The
Oh,
employee
yes.
then can't say, well, in that case, I want my old job
No,
back
you
because
can't.
it may be
You
full.
can't. Yeah. And of course you've moved on.
Yeah, that's right.
Yeah.
Okay, Ronnie, thank you very much once
a
again
pleasure.
for making yourself available. We've
you.
come to the end of the program. Viewers, thank you for being with us. Thank you, those of you who've called in. And remember, next week, the same time, Monday, we will be back, and Ashraf will probably be with you with another edition of Legal Ease. Assalamu alaikum wa rahmatullahi wa barakatuh.